And welcome to the 10th Annual State of Voting Rights Panel, sponsored by the ABA section of Civil Rights and Social Justice. My name is Jason Abel. I am a partner at Steptoe here in Washington, D.C., and I'm chair of the Civil Rights and Equal Opportunity Committee of the section. I'm honored to be moderating this event again this year, now a decade old. We're moving into our second decade of this panel, and really honored to be joined by this spectacular group of lawyers. For some thank yous, as always, thank you to Section Chair Mario Sullivan, section and committee leaders, and most of all, to the amazing staff of the section for their hard work in putting this event together today. The section is actively planning additional programming on a variety of issues, so please visit americanbar.org/CRSJ for important updates on these programs. Okay, before we begin, some programming notes. During today's program, we encourage you all to ask questions of our panelists through the Q&A. If you do not see the controls, please ensure your screen is not idle. We will be monitoring the Q&A and we'll do our best to address your questions, time permitting. We will also share a recording of this program with everyone who is registered, so please share it widely within your networks. Okay, so this year, the Voting Rights Act turned 60, and yet it seems like every day of 2025 brought a different challenge and a different threat related to elections and voting rights. Our panel today is on the front line of these voting rights battles. They will walk us through the various threats to the Voting Rights Act, election subversion, detail the mid-decade gerrymandering that we are seeing in areas like Texas, explain the administration's attempts to reshape the federal-state dynamic when it comes to elections, and walk through new state rules related to the franchise. I'll keep the intro short since we only have an hour, but note that these introductions themselves can take the entire hour. So in order of presenting today, we'll first start with Duell Ross. Duell is the Director of Litigation at the NAACP Legal Defense Fund. In that role, he supervises the LDF's cases, ensuring equal educational opportunities and equal access to the political process. Duell recently successfully argued Allen v. Milligan, which upheld the constitutionality of Section 2 of the Voting Rights Act, and he is a strong part of the legal team seeking to preserve Section 2 once again in Callais, which I'm certain he'll be talking about. Next up is Nina Perales, who is the Vice President of Litigation at the Mexican American Legal Defense and Educational Fund, MALDEF, where she oversees the legal staff and the organization's litigation throughout the United States. Her litigation experience includes not just voting rights, but immigrant rights as well. Nina is a voting rights trailblazer, having argued both LULAC v. Perry and Abbott v. Perez, and is currently lead counsel to LULAC, actively challenging the Texas redistricting scheme. Also, she is a former CRSJ council member too. Last but not least, Professor Rick Hasson. Rick is the Gary T. Schwartz Endowed Chair in Law and Director of the Safeguarding Democracy Project at the UCLA School of Law. Rick has literally wrote the book on election law, along with numerous other books, articles, and creator of the indispensable election law blog, which covers pressing issues and breaking election law developments. And last week, he filed an amicus brief in the California redistricting case as well. So as you can see, we have three very busy attorneys here that will walk us through exactly what is happening in the state of voting rights. So without further ado, Duell, I will kick it over to you to get us started.
Sure. Thank you so much for having me and for being a part of this really great panel of lawyers. So I was going to start by just giving a very broad overview of what's happening in the Supreme Court right now, particularly with Callais or Louisiana versus Callais, which is a case that LDF is involved in representing Black voters who have intervened in the case. So as I'll be very quick in a very long procedural history, but what happened is that in 2021, LDF and some other groups, including the ACLU, sued on behalf of a group of Black voters led by our client, Press Robinson, so the Robinson plaintiffs. We won that case at a preliminary injunction. It was then stayed by the Supreme Court for the 2022 elections and waiting for the decision in Allen versus Milligan to come down. When the Supreme Court came down with Milligan in 2023, the court said was that the Voting Rights Act was constitutional and that the existing framework for deciding voting rights cases would remain. The framework that I'm sure you'll hear us mention is from Thornburg versus Jingles, another LDF case from 1986. The Jingles framework is the existing framework under which the Supreme Court has said that's how you decide whether or not a redistricting scheme violates the Voting Rights Act because it has a discriminatory effect on Black or other minority voters. Afterwards, in response to that, when it went back to the Louisiana District Court, what Louisiana said is that they were going to take a shot at redrawing their districts. They drew it by adding a second, they did redraw their districts. They added a second majority Black district, but they did so in a way that was not as the plaintiffs, my clients, Robinson plaintiffs, had proposed doing it. Instead, what they did was they drew a district that went from southeastern Louisiana all the way up to northern Louisiana. And they did it in order to draw out a particular Republican incumbent that the governor at the time didn't like. And the result is a district that is not the most compact district, not the most beautiful district, but is one that the state drew expressly for political reasons. The Supreme Court has said for a long time that if you're drawing districts not based on race, but based on sort of partisan concerns primarily, then that is not necessarily unconstitutional. The Supreme Court about 30 years ago, trying to cover a lot in a short period of time, in Shaw versus Reno, said that if you intentionally draw districts in which race predominates, then that is unconstitutional. But the Supreme Court has said if you're drawing districts based on partisan data or partisan considerations like where incumbents live, then that is not racial gerrymandering. That's what, unfortunately, after Louisiana drew this new map, a group of, as they describe themselves, non-Black voters sued, and that is the Callais group of plaintiffs, in a different district court, got a 3-judge panel, said that the new Louisiana districts with 2 majority Black districts were unconstitutional racial gerrymanders, that they essentially used race too much in redistricting by setting this target of trying to draw 2 majority Black districts. And that panel moved very quickly. The whole case from like filing to a final decision on the merits was less than 2 months. We intervened in that case on behalf of Black voters. We're the only side that essentially got a chance to even really put on evidence about what the legislature was doing and experts. That case then went to the Supreme Court. We had argument about it in the spring. The Supreme Court decided that they wanted a re-argument, not just on this narrow question of what about Louisiana's district is constitutional or not, but whether the Voting Rights Act itself is constitutional, which is sort of a big surprise to us, given that the Supreme Court had just said 2 years ago the Voting Rights Act was constitutional. And so the fact that they wanted to hear re-argument about it rather than issuing an opinion about this Louisiana case, I think has set off a lot of alarm bells for the civil rights community and others. And that is also, I think, at least in part, a significant part of the genesis of why you're seeing so much redistricting at the state level now, is that there's sort of a concern that the Supreme Court was going to do away with the broad protections of the Voting Rights Act in a way that would make it much easier for Democrats and Republicans to eliminate majority-minority districts in a way that advances their political partisan concerns. And we had our re-argument in Calais in October, and we're still awaiting a decision from the Supreme Court. So that is a very quick overview of a very complex subject. I'm sure I'll get some other questions about other cases pending in the Supreme Court, but I think for me, at least, Calais seems to be the unfortunate, the Supreme Court wanting to reconsider the constitutionality of the Voting Rights Act, an unfortunate sort of genesis for a lot of the redistricting wars that you're seeing now and probably through 2026.
Thanks, Sewell. We'll definitely come back to that. That's probably impressive, fitting all that into just a few minutes. So we'll go from Louisiana to Texas. Nina, is there anything going on in Texas these days? Not
very
much,
little.
right?
We're just sitting around eating bonbons. One thing that I do have to correct was that I didn't argue Abbott versus Pettis. I did win the prevailing issue, but we, of course, as these cases usually involve many, many, many lawyers, we had another wonderful lawyer named Allison Riggs who did the argument, who is now, of course, on the high court in North Carolina.
I always try to give you more credit. So there we go.
Thank you. Thank you. All right, let's talk about the redistricting arms race, which was kicked off by Texas. The timing was interesting for a lot of different reasons. And one of those reasons was that we were actually in the middle of the redistricting trial in Texas. We were all in the courtroom in the middle of litigating the merits of the congressional redistricting plan that was enacted by Texas in 2021. It took us 4 years to get that case to trial because of a lot of discovery disputes that we had. So there we were, finally having our trial on the 2021 congressional map when this news story landed. I think it was from Politico, and the lawyers are looking at it on their phone thinking, oh my gosh, Texas could redistrict again. That is what ended up happening over the summer of 2025, was that Texas redrew its congressional map. Texas didn't leap to do this. The governor was very hesitant. The existing Republican congressional delegation apparently had a lot of heartburn about it. The governor had a special session that he had called, but he had not put redistricting on the agenda until the governor had a meeting with the White House and they discussed that maybe there could be a letter from DOJ urging them to redistrict. And that's exactly what happened. And that's where the kind of famous / infamous letter from DOJ came from. I think the only legal term to describe the letter from DOJ is hot mess, as we might say. Had a lot of really confusing interpretations of legal standards. And the bottom line was that it told Texas that it had to redistrict specifically to dismantle minority coalition districts. And those are districts that are majority minority, but the majority is made up of various minority groups. Once the letter arrived, the governor fully embraced the redistricting project, said about 1 million times on the news that he was doing it because of the DOJ letter and doing it to, quote unquote, get coalition districts out of the map. Texas redistricted, and we got to court as fast as we could because we knew that as an early primary state, we have a March primary in Texas that we were going to need to give our 3-judge panel, who was already there to hear the merits of the 2021 plan. They then took up the questions of the 2025 plan. The facts were rife with direct evidence of race-based redistricting. And the district court decision that came out was largely based on the direct evidence of racial gerrymandering. And that's the question that finally reached the Supreme Court on what's known informally as the shadow docket, because we got a preliminary injunction and then Texas went to the US Supreme Court to ask that it be allowed to put its new redistricting plan into effect for this upcoming election. The Supreme Court ruled in favor of Texas on December 4, which was last week, 4 days ago. Feels like 4 million years ago, but it was December 4. And there's an opinion essentially granting the stay that doesn't have an author. And then there's a concurrence by Alito, Gorsuch, and Thomas. And then there's a dissent by Kagan, Sotomayor, and Brown-Jackson. I've heard the Alito concurrence get talked about as the majority opinion, but I think it's important to note that that is not the majority's opinion. So the things that Justice Alito says there, I think we can understand most faithfully as the opinion of 3. But basically, the Supreme Court said that there should have been more deference to Texas, and this is also echoed in the concurrence. The decision is largely not turning on the idea that the election is coming soon, which is referred to as the Purcell principle. In fact, Purcell is not cited. So really what you can get out of this, although I'm sure there are lots of people with lots of opinions about what to get out of this. I think what you can get out of this is the Supreme Court saying that court should be very deferential to partisan redistricting. Kagan wrote a dissent that pointed out all of the direct evidence that we have of race-based line drawing in pursuit of partisanship. It's hard to ignore that in this case, Texas talked so much about race in its pursuit of partisan goals. But this is what we get. And now, of course, Texas is only the first of many states that has taken up redistricting. We have California has taken up redistricting, and their new map is already in litigation, also on claims of racial gerrymandering, except kind of the flip side of what's going on in Texas. And then we have other states that have been threatening to redistrict to pick up maybe, you know, one or two, right? On the blue side, Maryland maybe, you know, would pick up a seat. New York, maybe a seat. Illinois' candidate filing has already closed. So I think Illinois is super complicated because of that. And then you have a lot of other states, Missouri, Indiana, Florida, Kansas, Ohio, also talking about this. Not every state has done it. There's a lot of people who don't believe in it on both sides of the partisan aisle. But this is sort of an evolving situation. I'll stop there.
Great. Thanks, Nina. I'm sure we will come back to that as well. Rick, now over to you.
Well, thank you all. It's great to be back with you, Jason, and to be with Nina and Duell. I'm going to talk about something a little different, which is not litigation that's already happening, but what we might look forward to, or maybe that's the wrong way to put it, what might be coming in the next year as we talk about the 2026 midterm elections. And in particular, I have concerns, which I've never really had before, about the federal government interfering with the conduct of elections in 2026. Like usually we think of the federal government as the protector of voting rights. After all, it was the federal government that was sending down registrars and observers down to southern states when the Voting Rights Act was put in place to register Black voters. And the federal government has often played a very positive role in assuring that elections are free and fair. But with Donald Trump, things have changed. Donald Trump has consistently said that our elections are rife with fraud. He says that even in elections that he's won. Many people who support Donald Trump believe him. And I think that that creates a kind of reason to worry that Trump might use aspects of the federal government to try to influence the outcome of the election. And just to make explicit what the stakes are here, control of the House and control of the Senate potentially could be at stake in terms of how elections are run. And that, of course, is a different kind of worry about where there might be problems than in a presidential election, where we might focus on, you know, the swing states of Pennsylvania, Wisconsin, or something like that. Here, there could be close districts anywhere in the country. And so the problems could be anywhere. So what are the things that I'm worried about? One of them, perhaps the most blatant one, would be troops in the streets in American cities. We already have troops in the streets in American cities, but I'm worried that they might be directed to places where they might discourage people just from the hassle of, you know, worried about being harassed, legal American citizens, voters being harassed and not wanting to bother to vote. You know, we will get a ruling from the Supreme Court at any time about somewhat about the scope of what Trump can do in terms of sending certain troops into U.S. cities. There's a federal statute that says the troops can't interfere with the polling places, but they could do a lot of mischief even if they stay away from polling places. So that's one set of concerns. That's maybe like the most in-your-face kind of thing. I'm worried about a lot of other things. Trump issued an executive order last summer that purported to direct various government agencies to do things that might make it harder for people to register and vote, including telling the United States Election Assistance Commission that it needs to change the form that people can use to register for federal elections to require documentary proof of citizenship, which is something most people don't have easily available to them. We know that these kind of laws are disenfranchising of eligible voters and don't really stop any appreciable amount of non-citizen voting. Um, the uh, the lower courts have issued the 2 preliminary injunctions and 1 permanent injunction barring parts of the executive order from being put in place. Things are maybe a little bit more up in the air following today's oral argument in the Slaughter case, and there's concerns about whether the EAC, the Election Assistance Commission, can remain an independent agency and not be directed by Trump as to what to do. So that issue is on the horizon. So, and the use of DOJ to try to pressure states to do certain things. For example, the executive order directs states to not allow the receipt of absentee ballots after election day, even though state law allows it. There's a case at the Supreme Court that might shed light on that. So there's all of this stuff brewing. Trump has promised a second executive order that might be aimed again at mail-in ballots and voting machines. We don't know what that would look like. I'm also worried about Trump trying to pressure state and local officials to try and do the wrong thing in terms of how elections are conducted and how ballot counts are tabulated. Here, I think we need to look at the states and the people and the courts as the kind of bulwarks against that. So we have to make sure that there's transparency in how elections are run, that there are checks to make sure that election totals are accurately reported, that when the ballots are tabulated, there's the ability to confirm that and to observe that. So I've always looked at decentralization of the American election system as a kind of weakness, but here it might be a strength because, as a federal judge said in one of those Trump EO cases, the president has no role to play in the conduct of elections. The federal government is also trying to collect data from states to create some kind of database, to create some kind of super list of eligible voters and non-citizens on the voting rolls, or whatever it is that they're trying to do. I don't think this is going to be something that's going to be operable by 2026, but I think it might be in enough place that Trump could use whatever partial findings that they might be able to manipulate there to claim that there's fraud in elections. And of course, when it comes to Congress, it's not just the courts, it's also Congress itself that has to judge who's won elections when there are contests. So there's a lot of moving parts here, but I do worry about what the administration can do. And then the last point I want to make is about attempts to use the legal system to subvert election outcomes. And here I was very concerned with what I saw in the 2024 state Supreme Court race in North Carolina. That was a very close race between a Democratic incumbent who was ahead by about 750 votes over a Republican challenger. The Republican challenger went to court to try to contest the election. Nothing wrong with that, but what he was trying to do was to say that the rules that were applied should have been changed, and so retroactively throw out the votes of people who voted under the rules that they were in place. This raises all kinds of due process questions and equal protection questions. The state Supreme Court, which is itself quite a partisan institution, was going to partially allow this judge that was challenging the results of the election to try to do some kind of rejiggering of the vote totals. And it took a federal district court, very conservative federal district court judge in North Carolina, that said that this violates the US Constitution. And so I was very glad to see that ruling. It shows that across the political spectrum, there's a belief in some basic ideas. Like, we may disagree about the scope of the Voting Rights Act or even its constitutionality, but we agree that the winner of the election should be allowed to take office, and you shouldn't be able to change the rules for how you conduct an election after the election to turn an election loser into an election winner. I know that's a very low bar, but I'm hoping we can surmount that bar and end up on the right side of things after the 2026 midterms. And with that, let me turn it back to you.
Yeah, thanks, Rick. And it's sort of a sad or troubled state of affairs when we, like you just said, we have to applaud folks for doing the right thing, right? And surpassing that very low threshold. We will come back to some of the administration versus states and that interaction in a minute. I want to turn back to where we started and dwell specifically with the Callais case. When we talk about it, we we talk about the doctrine, we talk about the importance, right? But the practical impact of what might happen if the court goes, the wrong way on Calais. Can you speak a little bit to, and then obviously Nina and Rick, please jump in as well. What would the practical impact? What are the stakes here if Section 2 is essentially, ruled unconstitutional? Also, there's a private right of action dispute with respect to the Voting Rights Act. So for folks that maybe aren't as steeped into the actual doctrine, what do you sense as some of the practical effects of this?
Sure. I'll just start with your first question, or your last question, excuse me, about private right of action. So there are three cases actually in the Supreme Court right now in which the court has not issued a decision on. One is the Milligan case is back up there on after we won in 2023. Alabama passed a new map. We had to go to trial on that, and that case is back in the Supreme Court after our trial court win on both the merits, whether or not the court should affirm our win, and also whether or not Section 2 of the Voting Rights Act has a private right of action. I think the answer is very clear from the statutory text that there's a private right of action in the Voting Rights Act. It says that aggrieved persons may get relief, and it provides for only private plaintiffs can get attorney's fees. But for some reason, that has become a pet issue in the last 5 years of many states arguing that there is no private right of action in the Voting Rights Act. There are two other cases, Turtle Mountain, which you might have heard of, and also a Mississippi case that are also asking that same issue about whether there's a private right of action. So whether the Supreme Court in Calais, I'm hopeful that they don't get rid of the Voting Rights Act or say it's unconstitutional. Others on this panel may feel differently. But if they also say, whether they say that the Voting Rights Act is unconstitutional writ large, or they say that it's not privately enforceable, sort of has the same result, which is that states would basically have free reign, at least for the next 3 years, to eliminate majority minority districts and eliminate any kind of district that provides Black and Latino and other voters of color with electoral opportunity. And that means that our Congress and our state legislatures, our city councils, our school boards, all of them could go back to the pre-Voting Rights Act status that we had, in which certainly before the 1982 amendments to the Voting Rights Act that made it easier to sue under them, we had a Congress that, even though, as we know, much of the South, much of the Southwest have large minority populations, and yet many of these states had no Black or Latino elected officials, or very few of them, because states had the ability to use systems like at-large elections. They could draw, even though they have a white population that's maybe a minority, there's always a way to draw districts around it. And these really created just a total lack of representation for people of color across the country. And it was the Voting Rights Act, particularly in the 1980s, that addressed that problem. And so it's sort of really incredible in the same way the Supreme Court sort of got rid of Section 5 of the Voting Rights Act, which I think maybe we'll talk a little bit about, but that they're sort of using the success of the Voting Rights Act to say, oh, look, we have all these Black and Latino elected officials now. That means that we don't need a Voting Rights Act. But of course, we saw with Shelby County, in which the Supreme Court got rid of the pre-clearance protections of the Voting Rights Act, that states very quickly will backslide. And so the idea that you don't need these kinds of protections anymore, that these protections, sort of Justice Kavanaugh's argument seems to be that these protections have an expiration date, is really sort of incredible, especially what we know about American history and the years not only after or before 1982, but certainly the years before 1965, in which states just did whatever they want with respect to redistricting, and there was just no representation whatsoever in many places. And I'll just add briefly, it's often thought of as a problem with like red states that southern states will get rid of majority minority districts, but Democratic leaning blue states also have an incentive to eliminate majority minority districts. If you don't have to draw a majority minority district or an opportunity district for Black or Latino voters, then you can split those voters up in a way that allows for more white Democrats to get elected without Black or Latino voters having representation in Congress or in other state or local governments.
Yep, thanks, Noel. I think it was was it Justice Ginsburg that said it's like throwing out your umbrella because you're not getting wet in a rainstorm, right? So when we look at the stakes here with Calais, when you brought up Shelby County, right? So Shelby County, Section 4 and 5, right? The preclearance formula. 5 or so years ago with Brnovich, Section 2, but a different aspect of Section 2. When we look at what would have after Shelby County, there were numerous states that decided, well, we're going to put in place restrictions that they may not have been able to pre-clear. Can you all walk our viewers through just the process now, the safeguards that have now been really destroyed or weakened because of Shelby County, because of Brnovich? We just hit on Calais, but what have we seen in the past few years that have been leading to today? That's throw that up there for anybody.
Well, I can say that I looked for something I recently wrote. I looked at to find all the successful Section 2 non-redistricting cases since Brnovich. So just to be clear, Section 2 doesn't talk explicitly about redistricting. It just said that minority voters should have the same opportunities as others to participate in the political process and to elect representatives of their choice. The Section 2 litigation that Duell was talking about is about redistricting, and there's a whole formula and a multi-part test. But there was a question as to how Section 2 applied outside of redistricting. So before the Brnovich case, there was a case called VZ, which I think Nina was involved in, involving Texas's voter ID law. And in that case, the very conservative Fifth Circuit said it violated Section 2 to have this very strict voter ID law. And then since Brnovich, there have been no successful decisions because the way the court fashioned the test, it still exists on the books, but it's impossible to meet. So there have been no successful cases. I worry that we could see the same kind of thing in the redistricting context. The court doesn't have to kill Section 2 in order to effectively neuter it. And can I just share a slide for 1 second? Hopefully this will work. Let's see if this will work. Can you see that? So this is a slide showing the number of minority representatives in Congress from 1965 to 2023. And you see the huge bump after 1982 when Congress amends the Voting Rights Act to create the current Section 2. And I think I completely agree with Duell. There's going to be a bleaching not only of Congress, but of state legislatures, of local bodies, if Section 2 goes away, because both Democrats and Republicans will have incentives to move minority voters around to satisfy their partisan aims. And so I think it's going to be very difficult. What's going to be left are intentional racial discrimination cases, and the Supreme Court's already made those very, very difficult to prove, to come up with smoking gun evidence. So it would be a disaster, I think, if the court actually decimates what remains of Section 2.
I'd like to add that from the perspective of private plaintiffs, which is like the clients of the Legal Defense Fund or like the clients of MALDEF, we're kind of getting squeezed from both ends, right? When Section 5 and the retrogression standard effectively went away, we no longer had a partner in the Department of Justice to halt discriminatory voting practices, right? Instead, it has fallen to the private civil rights bar to litigate what would have previously been blocked under Section 5 through, the Department of Justice. We now have to litigate that and pour all of our resources into trying to halt those negative things, which is pulling resources away from our ability to do traditional Section 2 litigation, like Rick said. And the other end of the squeeze is that the standards are becoming, more and more punitive, and it's getting harder and harder to win these cases. But Rick, I would suggest that it's not just about Brnovich and the tightening of the standards, but it's about how much more is on our plates, because we have to now litigate so many more cases, and the organizations are kind of doing the best they can, but they may not have gotten to that particular non-redistricting issue, or, we used to do a lot of single member district challenges throughout the Southwest, which is districting, even if it's not redistricting. And now that redistricting has turned into decade-long sagas, I just got an email with a fee award from the 2011 litigation, which is now spun into Fifth Circuit appeals on the fees of the 2011 litigation. We don't do the type of single member district challenges that we did before, not because they're not there, but because we are trying to stay on top of all of these other things, plus the kind of hydra that decennial redistricting has turned into.
Yeah, and just to add on for the viewers that aren't familiar, I mean, LDF, MALDEF, you all don't just do voting rights work. There's a whole variety of other civil rights litigation and advocacy and, public education that, is obviously involved with your mission as well. So this, I'm sure, throws a wrench in that. Nina, I want to pick up on something that you just mentioned, and something that I'm sure our viewers are wondering. How do these redistricting wars end? Right? Or do they? I mean, is this just every state now will go and try to maximize quote unquote political gain? Or at some point, does it just stop somehow? And if so, what would that be?
I don't know what the answer to that is. I will say that although I am encouraging people not to read too much into the December 4th Supreme Court opinion, it feels a little bit like the court is being hands off in terms of what states might do. And if the approach is going to be hands off, I think that is throwing gas on the fire of the redistricting wars. This is a horrible mixed metaphor, but I think it will only encourage states to redistrict. And the court, by not citing Purcell, which I think was purposeful, also seems to be just focusing the spotlight on, well, if it's partisanship, we really need to be very deferential. So I don't see the Texas decision as doing anything to try to slow or halt the redistricting wars. And in addition, if Callais comes out and picks up on Justice Kavanaugh's enthusiasm for importing a deference to partisanship into Section 2 standards, it will be open season on existing minority majority districts, and it will open the door certainly for states, both Democratic control states and Republican control states, to redraw their maps ostensibly for partisan purposes, but in ways that dismantle majority minority districts.
I would just add briefly that both the per curiam order of the court in the decision last week, as well as Justice Alito's concurrence, mentioned California. I filed a brief on the side of California arguing that you have to look at the voters' intent, and voters did not intend a racial gerrymander. But regardless of that argument, the court seemed to be saying, I think Alito says, we all know what's going on in Texas and California. It was partisanship. Yes. It was odd to see this kind of dicta, a case that's not before the court. Hasn't even been a preliminary injunction hearing yet in California. So I agree with Nina that this seems to be a signal, although, I mean, I don't know what my co-panelists think. What would happen if a state decided to ignore one person, one vote and redistrict? Do you think the court would still stay out of it under the idea that it's one free, unlawful election? I mean, it can't be. There's got to be an upper limit. And actually, I think that Kavanaugh wrote a Purcell concurrence in a Wisconsin case during COVID, where he basically put out a test for when you might be able to get around Purcell. And one of those is the state has egregiously violated voting rights. It's clear cut. Like, maybe that's going to be the standard, but who decides if it's clear cut? So I do think that this is a green light for more redistricting. And one of the things I looked at just before I came on was when is the last date that the Supreme Court could issue a decision before the end of the year? And I think it's next Monday is the last scheduled opinion day. So it's possible Calais comes then, and that further affects redistricting. I would hope that they're so busy doing other things like dealing with the National Guard case that it will go into the later on in the year so that it will not lead to yet a third round of redistricting in places like Texas.
So zooming out on the federal level, or maybe shifting branches, supposedly co-equal branches, to the executive and the administration. And Rick, you had talked in your opening about some of this election subversion and the, maybe taking it a step further, the unitary executive. We heard, Slaughter v. Trump today, challenging really the authority of the president to, dismiss heads of independent agencies. You had mentioned the Election Assistance Commission and the president trying to direct that agency to do certain aspects related to election law. Where are the legal guardrails here? I know we'll know a lot after the Supreme Court opinion, but traditionally, with respect to federal, state, and even state local dynamics when it comes to elections, where are the guardrails? When should viewers really realize that not just norms, but maybe even the law has been breached when certain actions have taken place?
Well, I'll say I don't know that I would ordinarily call this good news, but the Election Assistance Commission is a very weak agency and can't do very much. That's good if you're worried about the agency being commandeered by someone who's not committed to free and fair elections. Similarly, the Federal Election Commission has been without a quorum, and I don't think Trump has even nominated anyone for any of the positions. So it's basically a dead letter for now. So maybe that's kind of like the Wild West of campaign finance. And the court's hearing a campaign finance case tomorrow, I should add, where they might loosen the campaign finance rules too. This is the NRSC case. So where are the guardrails? I said this briefly, but in my opening remarks, but let me just underline the three guardrails are the courts, especially the federal courts, that have done, I think, a pretty good job in terms of pushing back against trying to subvert election outcomes, even as they've not done a good job on voting rights. I think there is a line there. Second are the states themselves. Our system gives states, and states give to their counties considerable power, basically all the power to run elections, subject to certain federal constraints like compliance with federal statutes. And then the people themselves. I mean, really, if we were going to see federal troops trying to block people being able to get to the polling places, I mean, that would be a moment when the people would have to stand up and non-violently protest in massive numbers. I mean, I hope we don't have to be protecting our democracy in that way, but those are the kinds of things that stand ultimately the people, the ultimate backstop for a democracy.
Duell, do you have anything to jump on that with?
I was going to say that one of the things that has been really surprising to me is one of the things that Rick mentioned in his opening remarks, which is the compilation of national databases combining personal information about individuals, ostensibly under the guise of preventing non-US citizens from registering and voting. But as somebody who lives in a red state, folks are really vigilant about the ways in which government tracks them and tracks their information. And it's been, I think, really flying under the radar, the current administration's effort to combine not just federal databases like Social Security and immigration databases and other things like that, because we've never had a US citizen database nationally. Although we have databases of people who are born outside the US and have contact with the immigration system. Now we're going to have a nationwide database that includes information from motor vehicles departments from states, voter registration from states, Social Security, all of this other stuff combined together. And I think once you create something like that, it's really hard to uncreate it. So I believe that we are entering into an era where there's a lot more keeping track of people for the purposes of voting and maybe for other purposes as well. There's a lot of concerns that people who have names that sound like other people's names, are going to get caught up and misidentified in all of this. But over all of that is just the general idea of loss of privacy and the fact that it may become a new permanent way of our relating to the government.
I think all of you had mentioned at some point the relationship with the Department of Justice. From early days looking to enforce the Voting Rights Act to use your example right now, you have a letter from the White House. We have these requests, quote unquote, requests from the Justice Department seeking state voter rolls. Maybe Dual, we can turn to you first. What is your, and how is the LDF looking at really this? I don't know if it's necessarily new, but this posture of the Justice Department vis-a-vis the states, and what states have pushed back in a sense, saying, well, we're not going to really comply with these particular requests for a variety of reasons.
So I think Nina has maybe intervened in some of these cases, is that right? To defend against states, the federal government sort of going into states and trying to get people's information. So I'll let her speak to that specifically. But at least with respect to the concern about sort of the switch in the Department of Justice, I think with every administration, there's a changeover at the Department of Justice, and sort of sometimes the Department of Justice is more receptive than others. I also, though, don't ever want to let people think that like the federal government has been working and humming along just fine under the various administrations we've had in the last 20 years. There's always been problems and issues with its enforcement or lack thereof of our civil rights laws. I think it is particularly at an incredible and unique, at least as far as I know, time today in which the Department of Justice has wholesale been turned against voters of color, that it's being used to attack things that are being called illegal diversity, equity, and inclusion, to that it's being used in California to attack what's very obviously a partisan gerrymander, to say that and to use the Voting Rights Act to try to take away electoral opportunity for minority voters in the state. So I think that kind of weaponization of civil rights laws to go after minority voters on a mass scale, it's certainly something that various iterations of the Justice Department have done at a lower level, but at this level, with this sort of intensity, the firing or the departure of nearly all of the career attorneys at the Department of Justice means that there's really no backstop either, right? It's sort of, the 3 or 4 people who stayed or just got appointed and now have the entire power of the federal government to say that they're the Department of Justice Civil Rights Division and doing these things in all of our names, frankly, I think is what's really unique and disturbing and scary about this current moment that we're in. Yeah.
Nina, do you want to? I know you.
I think Dual pretty much summed it up. We haven't intervened in any of those lawsuits, but we're intervening in other collusive lawsuits between the federal government and states, not on our voting docket, as Jason pointed out. We also have a pretty active immigrants' rights docket, and we have been intervening in litigation brought by the Department of Justice against states to end in-state tuition for people regardless of their immigration status. So there's definitely, I think, that accompanying the Justice Department becoming more focused on presidential priorities and sort of seeing itself as the lawyers to carry out presidential priorities. We're seeing, I think, an uptick in what I would term collusive lawsuits, or, sort of negotiated, file the complaint and settle, like pretty much at the same time. In the in-state tuition case in Texas, the case was filed and got a judgment from the judge within a matter of hours.
That's remarkable. And, Rick, the idea that DOJ would be this entity to execute on, the administration or the president's wishes, frankly, at the expense of the voter, and particularly voters of color. I sort of see that as being election subversion and everything just all of a sudden now being mixed into one. Where does that, is sort of on a threat level, where does that rank for you?
Well, first of all, when I first read the letter that DOJ sent to Texas about how they needed to redistrict, I literally laughed out loud because it was such a bad um, analysis of the Voting Rights Act. Um, uh, so, uh, we could laugh at it if it were not so pernicious. When I hear Joel talking, I'm already thinking, yeah, I know, yes, we've got to get through the 2026 elections, but this country is going to have a rebuilding period. What's it going to mean that like the lawyers who don't get to go through the honors program, the lawyers who don't get trained at DOJ to be voting rights lawyers who end up going on to work at various public interest organizations, like that whole farm system is going to disappear. It would be, a badge of honor for people to work at DOJ. And now, you see many briefs being filed only with the names of political appointees on them for good reason, because the lawyers who stay do not want to be part of some of the things that are going on. And so, in some ways, it's been a self-inflicted wound for DOJ because they've had so much credibility with judges because they would not, play it fast and loose with the facts. They would, because they're representing the people, they would concede errors and do things like that. That's they've lost their goodwill, and so it makes them less potent. The fact that um, I think it was the Department of Justice put out a press release today that was calling out the judges as leftists on the United States Court of Appeals for the Fourth Circuit because they were ruling that Trump's handpicked U.S. attorney for the Eastern District of Virginia was not properly appointed. It's just they've squandered everything, and in some ways that's a good news story too, because it means that DOJ's power is somewhat lessened when they're being a force against voters and against democracy.
Yeah. So we talk about, and everyone's brought it up, right? So what happens when, right? And Rick, you used the example of, tanks in the streets and, nonviolent protests, change, resistance. And, that the first thought in my head was just how we got the Voting Rights Act to begin with was the protests were the lives lost and the blood spilled to push for voting rights. And what, if anything, can Congress do here in response to this? They're coming up against the Supreme Court that has obviously very strong views, but it wasn't that long ago when what was it, 99-1, the Voting Rights Act? It was in 2005 was reauthorized. We're pretty far removed from those days, but what can Congress do? Partisanship sort of aside in this sense, but are there new laws? Are there trying to strengthen the Voting Rights Act itself to try to safeguard against some of these actions?
I think the idea that there's going to be any legislation coming out of Congress that could pass both houses and that would be signed by the president or overcome a veto, the chances of that are zero. So I think what Congress can do the most, and I think this probably will depend upon Democrats taking back control because Republicans are allied with Trump, is the investigative power, the subpoena power, the impeachment power, that there are powers that Congress has, hold hearings, shine a spotlight. Already we're seeing some of that. And, as I said, I hope for a moment, maybe in 2029 or something, where there's going to be some rebuilding that's going to have to happen on a bipartisan basis. But in the meantime, it's going to require Democrats and Republicans and others coming together just to protect the very basics of being able to conduct elections. That's the base. That's the low bar. but then there's going to be a lot that's going to have to be fixed. And if Congress in 2029 passes some version of the John Lewis Voting Rights Advancement Act and dares the Supreme Court to strike it down, then that's another moment for either political protest or for changing the power of the Supreme Court. Because I think things have moved much more radically at the Supreme Court than many people recognized. And if the court is not going to recognize when the people, Congress has been the leader in promoting voting rights over time. The court's been the laggard. And it's really, if Congress leads and the court pushes back, there's going to have to be a response.
I'd like to follow up on that and go back to the slide that Rick showed. He was talking about 1982 as being that inflection point, right? And what happened in 1982 was that Congress clarified the Voting Rights Act in response to a Supreme Court decision that Congress didn't agree with, right? The Supreme Court said you had to prove intent to win under Section 2 of the Voting Rights Act. And Congress came right back and said, no, that's not what we mean. We mean the following, right? And then the Supreme Court understood that, and in 1986 came out with the guiding case that Duell mentioned, Thornburg versus Jingles. What Callais is, at least in part, about is what appears to be the appetite of the current Supreme Court to quote unquote clarify the Jingles standard and clarify the language that Congress has given to the courts. And I use clarify in quotation marks in part because it was something that Justice Barrett used that term. But it also seemed like clarify became a code word for this court to go against what Congress decided to do in 1982 under the guise of making sure that the act is constitutional or constitutionally applied. And so when I think about, first of all, Rick's point is well taken, the idea of congressional action in this direction seems like a remote possibility, but we also have a court that I think is not averse to taking what Congress did and saying, well, you know, we have to make sure it's constitutional, so we're going to chop it up.
And I will just end on hopefully a happier note, which is that states also have authority to pass state voting rights acts. Obviously, the Supreme Court can put constitutional limits on that as well, but a number of states, Virginia, New York, California, others have, put in place state voting rights acts that both have created private rights of action, no matter what happens in the Supreme Court for enforcement of the Federal Voting Rights Act, and also have expanded the kinds of claims and cases that you can bring under the Voting Rights Act to make clear that at least, even if we have a Supreme Court that sort of and a Congress that are taking a hands-off approach, there are state laws, state constitutional provisions that also protect the rights of many voters ahead of the redistricting and beyond. Excuse me.
So that's a great point. And you know, part of that too, just to also end on a more positive note. So there's a lot of viewers that are online right now that, you know, well, what can I do? Right? How can I get involved? How can I, you know, help protect the right to vote? What's maybe one piece of advice that you could give them right now as they're watching online moving forward into an election year?
Oh, I'd say that the elections are decentralized in the country. That means there's many opportunities to get involved, either as a poll worker or as someone who observes the process and makes sure that we have the backs of election administrators who are going to do the right thing, and that we're watching in case there is a rogue one who doesn't want to. But because it's so decentralized in every community, there is the opportunity to get involved in the election and voting process.
It's participation, participation, participation. You know, I live in Texas. I have a mixed set of friends and family members, and I tell them, I don't care what your political orientation is, just register and vote. What we do collectively here is really important, but the most important thing is for people to go out and vote vote their aspirations, vote their concerns.
So last word there.
Well, they all stole my thunder. I think it's really important, though. I will just really emphasize to people that many people are often thinking about these issues, voting rights issues, as happening at the congressional level, at the state legislative level. It is so incredibly important that people be involved in their county governments, their city councils, their school board elections. All of those things are where so much of the decisions are made about people's day-to-day lives. And so voting those elections, monitoring what happens with respect to redistricting or other decisions that are made about those elections, being a poll worker, as Professor Hassan said, all of those are things that are really important. And there are also ways in which you can be directly involved and be, a real important part of protecting our right to vote, even outside of the great work that the folks on this panel are doing.
Great last words. So we are at time. Thank you everyone for joining us for this free webinar. And just thank you, Duell, Nina, Rick, for your time. You're clearly very busy. So for you all to take an hour plus out of your days to speak to us, to speak to the viewers is very, very much appreciated. Couple closing housekeeping notes. The section of Civil Rights and Social Justice provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps in your work. I would not be invited to anywhere near the ABA if I didn't do a shameless plug to join the ABA section of Civil Rights and Social Justice. You can do so very easily online. Also, please stay tuned for more section initiatives related to voting rights. We will be producing a voting rights toolkit in the next month or so, which will provide practical resources and ways to get involved. Also, stay tuned for details about the section Civil Rights Boot Camp, which will be in its second year. Thank you again, Nina, Rick, Duell. It's always a pleasure to talk with you. And thank you to everyone for watching.